professional negligence cases have a very long shelf life. Even after you have retired, they still pursue you. So it's something very, very important. Incidentally, even us, as we are seated here, thinking we are okay, there might be a professional negligence suit against you or me brewing somewhere, and you don't know. You will know 3 years from today. Now, I'll not talk about the purely legal aspects of professional negligence because I understand you had an advocate of the High Court here yesterday, and I'm sure he dealt with the truly legal aspects. Now, by way of introduction, an overview of the recent court cases. One is the extremely high awards which have been granted by the courts. In the NCBA case, I call it NCBA as a professional courtesy to my professional colleagues. Let's talk of NCBA and Stand Big and all those, not about our professional colleagues. The court awarded 534 million to the bank. But that is only part of the story. If you read at the award or the court decision, the bank was also awarded interest at 14%, backdated from 2019 when the case was filed. If you do your simple maths, even with simple interest, you can see that NW Rewrite was required to pay just over $1 billion, plus costs. The other thing is the quick succession of cases. The last 2 years, we have had a very quick succession of those cases. We used to hear about one here and there, but now, all of a sudden, it's a very quick succession of cases. Thirdly, in nearly all the cases, the banks have won and the valuers have lost. I'm aware of only one case involving Equity Bank, where the bank lost both in the magistrate's court, and it certainly lost in the High Court when the matter was appealed. We don't have time to go into that case, but the other point, by the way of introduction, is that insurance companies have not risen to the occasion. We spend a lot of money paying premiums, but in all the cases, all the recent cases, I understand that insurance companies have bolted. They have disowned the valuers for some reason or other. The last bullet point there is that there are, in fact, now very many cases in the pipeline. They are in court. They have not been determined. Hopefully they will be determined soon. Professional negligence cases against valuers have some unique features. One is that the disputes are of a specialized technical nature. It's not purely about the law. The cases are in fact very fact specific, with each scenario being different from the next. Then there is the margin of error, which is generally agreed to be 10 to 15%. I've put a question mark there, because valuers who have gone to court defending their own valuations or supporting the banks or whatever have all agreed that the margin of error is 10 to 15%. Who told them? Who told you? Now, there are two issues arising from that. Textbooks talk of 10 to 15%. Fair enough, but those margins are from Europe and the United States. I have practiced arbitration in London for like 6 years. And I can tell you, the level of availability of comparables is unbelievable. You cannot get it wrong. There are so many comparables all over the place, published by the equivalent of Knight Frank and Haas Consort. You know the indices they give. But in UK, they go deeper. In every neighborhood, if you do a Google search, just a Google search, you get like 100 comparables of properties within a neighborhood, all verified, certified. So when you read in textbooks that the margin of error is 10 to 20 to 15%, it's there where so much verifiable and public information is available. Our situation is different here. Even statistics, you know better than me, even statistics from the Lands Office are not reliable because of reasons that we know. Yeah? Government databases should be the ones with the best comparable information. Ours are not. There is no published, there is no publicly accessible database I know of with respect to comparables. The figures we get in the Knight Frank reports and Haas Consort reports, when you look at the methodology, serve a certain purpose, but they might not be suitable for use in valuations. Certainly they are not comparables. So I have a question mark about that margin of error. The second question about the margin of error is 15% of what? Is it 15% of the bank valuation of the auction sale or 15% of what? I am writing an article about that and I will circulate it among valuers in due course. But it's a very interesting question because courts take 15% to be a margin of the bank's valuation or some valuation. It's a very interesting area. Then there is the issue of contributory negligence. This featured, I think, in the Guarantee Bank case. The court found that the valuer was negligent, but the awarded damages were discounted to about a third or 30%, something like that, because the court considered that the valuation was not the only factor which the bank considered when lending the money. There were other factors and there were other failures in the system, not just the valuation. So the valuer should not be blamed alone. The other point is that a valuer is not negligent just because his or her figure is different, just because it looks high or it looks low. You need to look at the methodology. And in the NCBA case, if you have read the details, the subject property is really unique. It is at the coast. Part of it is submerged in the sea. Part of it is at the mangroves. But that land has potential for salt mining. So you are not just dealing with an agricultural property. You are dealing with a property which has a potential for salt mining. So the fact that a valuation looks high, the figure looks high or looks low, doesn't necessarily mean that the valuer is negligent. Then there is the long shelf life. As I alluded to earlier, sometimes it takes a very long time after the property has been valued for the borrower to default, the bank to start auctioning, and then to discover that there is a problem. Now, also, from the discovery point to the arbitration or to the High Court or Magistrates Court, all the way up probably to the Court of Appeal, it takes a couple of years. I have worked it out to be from the date of valuation to discovery, allow 2 to 5 years. From valuation to discovery, 2 to 5 years. From discovery to arbitration stroke litigation, 2 to 5 years. No, let's say 3 to 5 years. From appeal, let's assume an appeal, another 3 to 5 years. And then enforcement or recovery against the valuer, another 2 to 3 years. You will quickly see that from the date the valuer did the valuation to the end of the spectrum, recovery, we are talking of 12 to 15 years. It's a long, long time. And because of that, it becomes a health issue. Those of you in the industry know that some valuers have passed away when they were confronted with professional negligence cases. They just couldn't cope with the shock, the stress, the threat to personal assets, etc., etc. So it even becomes a health issue. I'll make a few observations about the Stanbic case. One is that the arbitrator was appointed by the Chartered Institute of Arbitrators. The arbitrator was a lawyer. The third point is that very few valuers are professionally qualified as arbitrators. I know this as a fact. Last year I was involved in a matter and I needed to recommend somebody, needed to recommend a valuer for appointment. And I searched and searched and searched. And it was difficult to get somebody. The few who were eligible could not be appointed because they either had bank accounts of that bank. So they were conflicted. They couldn't be appointed. So when you see Chartered Institute of Arbitrators appointing lawyers, it's because valuers generally have shown disinterest in arbitration. And it's not for lack of trying. I have personally tried. Chartered Institute of Arbitrators has tried to engage ISK with a view of training valuers in arbitration matters, but the program could not proceed because the uptake was not good. Now, in this particular case, from the date of the appointment to the date when the arbitrator completed his work is about 12 months. Now, the valuation firm was represented by a lawyer in the arbitration. This is important because in arbitration, you can represent yourself just like in court, but you could be represented by another valuer. Yeah? There are valuers who are trained in arbitration and in arbitration process. Some of them are actually lawyers, but even those who are not are familiar with arbitration process and could represent valuers in arbitration. So that's an overview of the Stanbic case. What lessons can we learn from it? One is that lawyers are lawyers. Sometimes they understand the law, other times they don't. Yeah? It's, my guess is 50-50. Sometimes they get it, other times they don't. But whatever the case, lawyers cannot understand the practical aspects and nuances of property valuation. This is a very complicated field for outsiders or for non-valuers. I give the example of case law. Some of us are blinded when we look at a case decided by a court. We can't make head or tail. Now, that is the same way lawyers get lost when they are confronted with mutation plans, survey maps, and building plans. They get lost completely. So, valuation cases are actually quite technical. And it's difficult to get a lawyer who can understand the practical aspects and the nuances of property valuation. The next point is that judges, in case you have forgotten, are lawyers. So what I have said about judges, about lawyers previously, is true of judges. So they will decide the case the best way they know, but unfortunately, they might not address some angles which are very important. I would like to talk briefly about ADR procedure. Now, negotiation is the oldest and best and most common method of resolving disputes. The parties engage directly, and the process is fast, cost-effective, and maintains relationships. That point of maintaining relationships is very important because even when a valuer has been wrong or negligent, that should not be a death sentence. There is still life after professional negligence. There is life after an overvaluation. There is life after an error. And there is nothing stopping a bank which has suffered loss from a valuer from continuing doing business with that valuer. Okay, something has gone wrong, but if the situation is handled well, the parties can still continue engaging in a business and a professional relationship. And negotiation facilitates that. Now, because there's privacy, there is also absolute confidentiality. It's only the valuer and the bank who knows that there has been a problem. However, there is power imbalance, and it is to the detriment of valuers, that power imbalance. When you, even just the venue, when the valuer is summoned to the bank manager's office and is kept waiting for 2 hours and has to beg to get the key to go to the toilet, all that is power imbalance. It's not accidental. It's power imbalance. And it works against valuers. You go to the bank as literally a beggar. That is why it makes sense to attempt mediation, because in mediation, there is another party. There is a neutral person who stands in the middle and makes sure that the ground is level. Both of you are level. You can negotiate sensible terms. Now, when you are summoned by a bank manager, many of the valuers just agree to what the bank manager is saying, which is basically that you take over the loan which somebody has taken and defaulted. You really are quite helpless. But when the ground is leveled, then you can also put your own terms for consideration. You don't dictate. Neither party dictates to the other. You negotiate in the presence of a third party who is a professional and is trained in that area. That leads us to arbitration. As you know, the Stanbic case was arbitrated, but then the party which was aggrieved by the arbitrator's decision went to court. Now, arbitration is very much like court. Unfortunately, it shouldn't be, but that is what it has turned out to be. There are several advantages and disadvantages. The advantages are the process is confidential during the arbitration. During the arbitration, nobody other than the bank and the valuer know that there is a problem. And that is important. Confidentiality is important because reputation is the valuer's greatest asset. It's not the office, it's not the vehicle, it's not anything else. We survive on our reputation. And the minute word goes out that so-and-so has overvalued or so-and-so has a serious dispute with such and such a bank, it's not good for the valuer's reputation or the valuer's business. So confidentiality is very important. Now, the other advantage is that the dispute can be determined by a valuer sitting as an arbitrator, because the valuer understands the practical issues and the nuances and the context of valuation. Also, as I said earlier, the valuer can be represented by a valuer. Sometimes it's not good to represent yourself because you get too emotionally involved and you are not sufficiently detached to make a sensible representation of yourself. It helps to be represented either by an advocate or by a valuer. But if you are seeking representation instead of attending yourself, then you might as well be represented by a valuer, because a valuer understands these things. The other advantage is the finality of the arbitration award. So when it comes to the disadvantages, we also have the finality of award. It's plus, and it's both an advantage and disadvantage, depending on the way you look at it. The advantage of finality is that it saves time and costs. Once it's decided, and that's it. Parties move on. The disadvantage is that because to err is human, if the arbitrator gets it wrong, then you have no chance of an appeal, a proper appeal against an arbitration award. There are very limited grounds on which you can attack an arbitration award or file an appeal. The other factor is costs. Arbitration can be quite costly. And because of that reason, it is unsuitable for low-value disputes. If the dispute in a professional negligent claim is about £1 million shillings, you cannot take that to arbitration unless you really are sure that you are going to prevail. But even then, the costs could be disproportionate. The next slide is still on arbitration, and it's on how to make the best use of arbitration in valuers' professional negligence disputes. One way to make good use of arbitration is to attempt mediation before arbitration. Mediation is better than arbitration because the parties settle the dispute on their own terms. In arbitration, somebody else determines the dispute for you. In mediation, the parties agree on the terms. So it's a superior method to arbitration. Therefore, it is advisable to always attempt mediation before arbitration. Actually, our courts have now changed a lot in the last couple of years. They encourage parties to attempt mediation. Even cases which have been filed in court these days are sometimes referred to mediation. The other way in which we can take advantage of arbitration or make the best use of it is to name ISK as the arbitrator appointing authority. In the Stanbic case, as I said earlier, the arbitrator was appointed by Chartered Institute of Arbitrators. And many of the arbitrators there are advocates, while in fact very few qualified arbitrators are valuers. So if you send a request to CIAB for the appointment of an arbitrator, chances are that a lawyer will be appointed as the arbitrator. Now, by naming ISK as the appointing authority, you make sure that the person who is appointed is qualified in valuation matters, because ISK would not appoint an unvaluer as a dispute resolver or as an arbitrator. But if you name another institution, like Nairobi Center for International Arbitration, or Law Society of Kenya, or Chartered Institute of Arbitrators, then you should specify in the arbitration agreement that the person appointed must be a registered valuer. Let it be the appointing authority's problem to identify a person who fits within that qualification. Then the other point is to consider being represented by a valuer instead of a lawyer. The last point there is that for very high value disputes, like if the disputed amount or the claim against the valuer is like 500 million plus, then it makes sense to have a provision in the agreement that the tribunal should be made up of 3 people instead of 1. To err is human. We have seen cases where judges and arbitrators get it wrong. One of the ways to mitigate that risk is to have 3 arbitrators resolving the disputes. In such a case, the valuer appoints 1 arbitrator, the bank appoints the other arbitrator, and then the 2-party appointed arbitrators appoint the 3rd arbitrator who chairs the tribunal. So that brings me to the end of my presentation. I have left out some points because I would like us to have a session of question and answers. What I would advise is changing that clause to provide for mediation, because mediation is much less expensive, it is faster, it is confidential, it's a viable proposition. Yeah. So an ideal arbitration clause should have a provision for mediation before arbitration. Actually, mediation is very effective, especially the court-annexed mediation. If you do a Google search, there is a YouTube clip by a lady called Kedago. She was the registrar of the court-annexed mediation until last year when she became a judge. She has some statistics in that clip. The clip is only 45 minutes. It talks about how the system works, how many cases have been referred, how many mediators there are. You'll be surprised. The court-annexed mediation has, I believe, like 2,000 mediators properly qualified and certified by the judiciary. So there is a lot of capacity in court-annexed mediation. Now, when it comes to private mediations, there is a little challenge there. We don't have many people practicing mediation outside the court-annexed mediation. But that sector is also growing. The future is bright for mediation. We are not there yet, but we are getting there. Yeah. Another question or comment? Let me comment on the President's remarks. He has given us an example of a mediation which worked, even though the matter had been in litigation. he has also said that he allows for 3 dispute resolution mechanisms, the same ones I talked about. Attempt negotiation. If that doesn't work, go to mediation. If that doesn't work, go to arbitration. I could not have put it in a better way. Now, as for the grounds for setting aside, they are laid out in the Arbitration Act. There are like 7 or 8 grounds. The most common is public policy. If an arbitration award has offended public policy, then the award will be set aside. The other grounds are, for example, if there is evidence that the arbitrator was corrupted or conflicted, then the award will be set aside. Those are just examples of the grounds on which an arbitration award can be set aside. These things happen. Before I take the question, let me make 2 comments about what our brother here has said. Professional negligence among valuers is actually quite common worldwide. When you have a bit of time, just do a Google search of the 7 largest valuation companies in the world. Once you have those names, do a Google search of each one of them in terms of professional negligence cases. You will be shocked. All the big valuation companies worldwide have been found to be negligent one time or other. Now, just recently, I think last week, I read an article in the newspapers about PwC, the auditors and consultants. They have been blacklisted by the World Bank for a period of 21 months for some misconduct. But they resolved it through negotiation. They didn't go to court. World Bank and PwC sat down and said, these are the issues, this is what we admit, this is what we deny. We still want to do business together after some time. So it was a negotiated settlement through negotiation. Now, the other thing is that, and I'm now responding to President Emeritus' comment about the disadvantages of arbitration to the extent that some people and companies are no longer prepared to go to arbitration. I'll give you an example of divorce. If you talk to somebody who is undergoing divorce, you will think that everybody is about to divorce. Yeah? Yet, the reality on the ground is that people are still going for coffee dates to explore the possibility of marriage. And there are actually people who are still getting married. Tomorrow is Saturday. There will be traffic jam on Thika Road and Limuru Road as people go for weddings. So with arbitration, it's the same, unfortunately. There are people for and people against. The choice is made at a personal level depending on the circumstances. So for young people here who are not married, or even elderly people, I would say, look at the advantages and disadvantages. Arbitration is not suitable for each and every dispute, but there are certain disputes which should certainly be referred to arbitration. The alternative to arbitration or to out-of-court settlement is actually going to court. And that is what keeps bringing back people to arbitration. When they go to court and a matter takes years, and when you look at the decision, it is not satisfactory. The Stanbic case was referred to arbitration before it went to court. The NCBA case was not referred to arbitration. It went straight to court. You can read the two side by side and decide which one was a better, gave a more reasonable outcome. But there is a case for arbitration, and there are disadvantages to arbitration. Actually, I have written an article, I think it's on my website, titled 30 Myths About Arbitration. 30 of them, myths about arbitration. Much as I practice arbitration, and I'm all for it, I've never imagined that it is suitable for each and every dispute. There are some disputes which should not be referred to arbitration. However, in professional negligence cases, because of the confidentiality aspect, I think they are particularly suited for arbitration. There are several possibilities. One is to take advantage of Section 39 of our Arbitration Act. It says that actually, if the parties agree to have a right of appeal, then either party can appeal against the arbitrator's award. It's a very interesting provision. Unfortunately, parties don't take advantage of it. Now, it's easy to assume that banks are happy with what is happening in our sector. Actually, banks are not. They are probably more aggrieved than we are, because some of them have been unable to enforce those court judgments because valuation companies don't have assets. Basically, just one or two cars, some office furniture. They have no assets, and they are limited liability companies. So to recover, you have to go another level of lifting the corporate veil, which has been, I understand, unveiled in the Stanbic case. But it's a lot of headache for the bank. Banks are not in the business of taking valuers to court. They are in the business of lending and earning interest and commissions. When they have to go to court, it costs them money, it wastes their time, it diverts them from their strategic focus. Banks are not happy. They would be happier with mediation if it is proposed, in a sensible manner. They would also be happy to have the leeway of appealing against arbitration awards, because the way valuers are constrained is the same way banks are constrained by the finality of arbitration awards. So, when it comes to the service level agreements and the arbitration clause, those are the things we should consider so that the banks have their rights, but the valuers also have their proportionate rights. Also, it is in the arbitration agreements and probably the service level agreements where we should provide the qualifications of the arbitrator who will arbitrate the case. I'm sure some of you have seen arbitration clauses which say the arbitrator must be an advocate with over 10 years of experience. There are cases which we should insist on having arbitrators who are valuers with more than 10 years of experience, or even more than 20 years of experience. Why not? But these things can only be incorporated in the service level agreement or in the contracts through negotiation. There is a problem there, but it's actually a complex problem. One reason why insurance companies are able to avoid these claims is because valuers do not report the incidents in time. Just like motor vehicles, if you get an accident, you are supposed to report within how many days or how many hours? How many? 24 hours. So if you get an accident now, within 24 hours, you are supposed to have reported. Now, I'm not sure about the timelines in terms of professional indemnity covers, but you must report as soon as possible. There might even be time limits. I don't think they are 24 hours. But you see cases where valuers receive demand letters from the bank. They first suffer trauma and shock and confusion. Then they start defending themselves. Actually, the way insurance works is that you should not even defend yourself. The insurance company is supposed to defend you, to engage a lawyer to defend you. But if you say you are going to defend yourself, then you are starting to distance the insurance company. If you did not report on time, you have breached the conditions of insurance. Yeah? There is also the matter of who inspected the property, whether the person who inspected the property was a qualified valuer. And a qualified valuer means simply one thing in Kenya. What does it mean? RV, registered valuer. Nobody else is a qualified valuer in Kenya if not a registered valuer. Now, if you look at our constitution, we have a category of members known as graduate members. Are they allowed to use ISK initials after their names? They do. They use GMISK. I would like to hear from the president because there is no unanimity among the audience. Mr. President. You have heard that? They are recognized as graduate members, but they are not authorized to use GMISK initials. Now, under our constitution again, the registered valuer or the full member of ISK takes responsibility for the conduct of the of the graduate members. So, if you are signing a report, up there it's a graduate GMISK, which we have agreed is a fictitious initial, unlawful and fictitious. You have heard it from the president, not from me. It's the president. If you have questions about that, seek the president for clarification after this. But I've actually read the constitution, our constitution, with respect to that aspect. Because when I am challenging an arbitration in court, I also act as an expert witness. I look at that and I tell the court, the person who has signed here is using imaginary qualifications. And I produced the Constitution. Yeah, so these are very simple issues. Today, my presentation today has been on the surface. Now, Kenya valuation standards. That is a time bomb. I have done a survey, I can tell you here, believe it or not, the level of compliance with Kenya valuation standards is next to zero. Next to zero. And I tell valuers, if you think that claim is baseless, just give me today a valuation report from your company or from another valuation company done the last 1 year. And I will show you that it does not meet the criteria given in Kenya valuation standards. You'll be shocked. That is my specialization. Giving expert evidence in court and in arbitration about Kenya valuation standards and all that. It's really amazing the way valuers don't bother with Kenya valuation standards. So the first step in avoiding negligence claims is to make sure that you comply with Kenya valuation standards, incorporating international valuation standards. It's a book. It's not a line which you put in your valuation that this valuation complies with Kenya valuation standards. It's a book. There is the question of the substance. Does the substance of your report comply with the Kenya valuation standards? It's a book of about 150 pages. You need to master that book. I can bet here not more than 5 valuers have read the Kenya valuation standards. I can bet, not more than 5. So, because as I said earlier that professional negligence cases have a very long shelf life. Kenya valuation standards were introduced 5 years ago. So, cases have not started arising from the disregard of Kenya valuation standards. They will start arising next year, 2020, 2028, 2029. Yeah, and by that time they will have been reviewed because they are under review. Yeah, that's a very good question. And it's a discussion we need to have within the profession to decide the role of the graduate members as they gain experience in order to become registered valuers. The way our industry operates, the way it is structured, is that the graduates render a very important service to the profession. However, there are some limitations. If you go to a law firm, you will never be served by a trainee in a law firm. In a law firm, non-qualified personnel give backroom service, but they don't sign anything and they don't go to court. I think we should learn something from the legal profession. The graduate members have a role to play, but we need to have a very serious discussion within the profession to decide what that role should be.
What do we look for? Thank you.
Yeah, thank you, President Emeritus. That is very important. Actually, what President Emeritus is not saying is that insurance companies will not pay if the property was inspected by a graduate member. Please let that sink. Thank you.